court's analysis. What I would, I guess, bring up to the court is I think, and from reading the transcript last night, one of the issues is that the term post-certified and peace officer they've been kind of interchangeably used, and they don't mean the same thing. A peace officer is post-certified as a peace officer, as well as in this, based on what you said, I would, I guess, submit to the court that everybody was post-certified during
All six.
Yes, on September 11th, 2018, but they were all post-certified jailers. They were not post-certified peace officers at the time of the incident. So that's a huge distinction. It makes that a post-certified peace officer has arrest powers. A post-certified jailer does not.
So I'm not going to remember it well enough, but my recollection was that some lawyer said, well, my client wasn't, and maybe this is sloppiness on my part or not a full enough understanding. I thought that some of the lawyers, defense attorneys represented, well, my client wasn't post-certified then, but between now and then, he or she has become post-certified. And in looking at the case law, that's not interesting, not relevant. It may be interesting, it's just not relevant. It's your status at the time of the incident that would be the subject of the alleged criminal conduct. So it would be the date you just gave. But what you're saying, Mr. Abate, is that you believe if we were to look in official records, all six are post-certified because you'd have to be to get the job that you filled, but you were maybe you can be post-certified as a justice of the peace, as a bailiff, and those things for which you are post-certified are very different.
Yes.
And not all of them carry with them arrest powers. And my read of the case law was that arrest power seems to be that magic ability that someone has. And my error was to conflate post-certification with arrest power.
Yes, and
I could be post-certified, maybe as a judicial officer. I know I cannot arrest anyone.
Right.
Okay, I'm not post-certified, just so we're clear.
Well, I wouldn't put it past you. So.
Okay, someday. It's a longer test. So one observation you're making is don't be overwhelmed if all the defense attorneys provide proof of post-certification as of the date of Mr. May's death, because that's not the yardstick you should be using.
Correct. And
Okay.
I have I guess it'll be a joint decision whether we need an evidentiary hearing or not. We do have somebody from post who is here who can testify, but I also have the records that I attached to the state's motion to reconsider. I have certified documents of each defendant's post records, which would show when they were post-certified jailers and when they were, if they were received the certification for a peace officer. There are, I believe, 3 of them who, after the incident, did get the certification for a peace officer. Mr. Cook and Mr. Roach and Mr. Strouder, Miss Strouder, I'm sorry, all got the peace officer certification after September 11th of 2018. And I have certified documents for all of them, but there is a witness if necessary, Your Honor.
Okay, well, we'll see. We'll work through that. But you're saying at the time, on September 11th, 2018, you believe the records show that all 6 were post-certified. None was post-certified as a peace officer.
Correct.
Subsequently, Cook, Roach, Strouder got promoted within post, if you will. They got post-certified in a different capacity. Peace officer, which in theory gives them the power of arrest.
That's correct.
Query whether they could arrest anyone in the jail or not. I know that was another part of the debate is, are they really keeping public order in a jail as opposed to out on the streets? But arrest power seemed to be a pretty bright line that the appellate courts had drawn. And so what you're saying, and why is it that you say, Mr. Abate, that a jailer doesn't have the ability to arrest? And I'm not asking from the sheriff's perspective, because that may be evidence that we should gather as well as what had the sheriff authorized jailers to do. But post-certification as a peace officer includes the power to arrest?
So no, yes.
Even if you're not, do you have to be associated with a law enforcement organization, or could I go to post and get certified. I don't work for Atlanta Police Department, but I could walk around arresting people.
So you have to be associated with the police department. So I guess it's for analogy purposes, like to be
No
a lawyer,
free agents.
right? To be a lawyer, you have to pass the bar first. Here, you get the job as a police officer, and then you go to the basic training or mandate in order to take the 408 hours to become a post-certified peace officer, allowing you to do the actual job at the whatever agency you've been hired at.
But there is also a post-certification for a jailer.
Yes.
So it's sort of like you can get an associate's degree, you can get a bachelor's degree, maybe as a peace officer, that's additional. I assume it would be additional because you have been given more power.
Yes, a jailer, it's an 80-hour course versus the peace officer, it's a 408-hour course, which takes 11 weeks. And the jailer course takes, I believe, 2 weeks.
Okay. How many hours did you say the peace officer was?
It's 408 hours initially, and then each year, a
Yeah.
peace officer has to get 20 hours of continuing education.
Okay.
That involves de-escalation, firearms, and community policing, while a jailer does not have to do any continuing education.
So if I wanted to work for the sheriff, any sheriff in Georgia, as a jailer, I might get hired as a jailer. I need to get that post-certification only. It's still a lot of hours, but only 80 hours. That would give me a certain authorization to function as an official jailer, which would not include the ability to arrest someone. But if I wanted to join the Scorpion Squad for the sheriff, I would need to go back to post, get that peace officer certification, because otherwise I wouldn't be so helpful on Scorpion. All I could do is say, if you were in jail, I could make you go from cell 1 to cell 2, but I can't arrest you.
Correct. It's like a paraprofessional who works at a school. They assist, they can't teach. In order to teach, they have to get the teaching certification that all teachers get. So it's just like that.
Okay. That's helpful. Why don't I get some input? Well, let me ask you, what is your preference as to how we proceed? Do you think that the certified records from post showing that none of the 6 was a post-certified peace officer, all 6 were post-certified jailers, that is sufficient? Is there more you want to get in the record today, or when we reconvene with everyone having noticed that it's going to be in that format?
What do you think? I think the records would be sufficient. In order for them to be sufficient, I think the defense counsel would have to, I guess, concede the fact that nobody was a peace officer at the time. And if not, I think that's when the agent from post would probably be most beneficial and necessary to explain, the post records for each one of the defendants.
Okay. All right. Well, thank you for pulling that together. Let me turn to the defense side. I don't know if there's a particular order in which you all want to go. If you have, everyone points to Ms. Clark Palmer. Yes, ma'am.
You go first. Mr. Pines is going to go first.
All right. Mr. Pines, good morning, sir.
Good morning, Your Honor.
And remind me, you represent?
Mr. Whitaker.
Mr. Whitaker. Excellent.
And Your Honor, I don't know if you've had a chance to review the transcript. I don't know who the state is claiming said that their client was post-certified because it's not in their motion. But I made it clear during the hearing that my client was a post-certified jailer, but that still he's entitled to the benefits of the statute. So our position hasn't changed. I don't think that the ruling should change. And that's really all I have.
Okay. And I'm not, today isn't a day, I don't think ever is a time where I want to pin someone, hey, you told me X. I may have been laboring under the misapprehension that that there was only one post-certification. If you were post-certified, you could work at the county jail. You could also work for GBI. You could work for APD. And I'm learning now that there are different tiers of post-certification. And so it may well be that the lawyers who represented during that hearing we had in the middle of last year were simply saying, no, my client was post-certified. The part that left me confused and I injected into my order saying that 17,752 had been violated is that I do distinctly recall, I think the transcript would show this, that some of the defense attorneys contrasted their clients with others. Oh, well, my client wasn't X at the time, but has since been. And so, again, maybe my error, I'm happy to correct my error. If I was conflating post-certified jailer as a defense attorney saying, no, my client had the powers of arrest at the time Mr. May died.
Sure. I mentioned it was the distinction. The court kind of brought that up in the colloquy with me.
Mhm.
So that was, I know the court has conducted thousands of hearings since then, but it's on pages 31 and 32 of the transcript where I mentioned that the state, that my client's post-certified jailer, I used the term distinction, and then the court on page 32 says, got it. So your client, Mr. Whitaker, is like Mr. De La Cruz, post-certified throughout. We just don't need to wrestle with that issue. And I say he's a post-certified jailer, which I think the state, and then you say, oh, there may be a distinction in the state's mind.
Okay.
That's sort of where we left it.
Got it. And tell me before you sit, why you think do you believe a post-certified jailer enjoys arrest powers?
Yes.
And how is that? So what's the benefit of the additional 328 hours of training through post to become a
There's
piece?
a difference about being a police officer in the street and being a detention officer at the jail. I mean, clearly jailers are moved throughout the jail without their consent. They are, otherwise it'd be false imprisonment. So it is a form of being able to take custody of somebody and move them against their will. And otherwise it would be a false arrest or false imprisonment rather, without lawful. If my client was moving somebody without lawful authority, then he would, technically be committing a false imprisonment.
But these are folks already in jail. And so your client wouldn't be responsible for their presence in the jail. Your client would be relocating them in a place where they're either wrongly imprisoned, but that's not your client's business, or they're simply relocating them in a place they are lawfully present. What's the arrest part of that?
Well, the arrest, I guess the problem is arrest isn't defined in this part of it, and peace officer isn't defined in this part of it.
No.
And so, my opinion is when you look at the words of the statute, since it isn't defined, it goes to our client's benefit. And so, he's a post-certified jailer. If we need to have more evidence on what that means, then we can have more evidence on what that means. He's just not a police officer who's allowed to be out in the street.
Got it. Okay. Thank you. Ms. Clark Palmer, good morning.
Morning, Your Honor. I would encourage the court to stand by your original ruling in light of the fact that there's no new information you've gotten today that you didn't have at our hearing last year. And I would note a few things from both your order and also some arguments that the state made in their motion to reconsider. Your order did talk about how one bright line is the power to make arrests, but that's not the only test that we have to go by, because the statute does talk about other parts of it. In fact, the statute talks about, let me move on because I'm talking about the statute in OCGA 16.1.3.11. And this comes from the part of your order where you were talking about the lack of a definition of peace officer in Title 17. But when we go to Title 16 and we look at the definition there, it talks about more than just the power to make arrests. It talks about somebody who by virtue of their office or public employment is vested by law with a duty to maintain public order, and whether that duty extends to all crimes or is limited to specific offenses. So that's one part of it. We can't just look at just the power to make arrests and say, well, that's the end of the inquiry.
No, I don't
Right.
disagree with that. I thought I had found a shortcut to resolving this because I misapprehended I think I continue to. I appreciate Mr. Pines's creative argument that jailers can arrest because they're able to move people around in the jail and that is taking them into custody. But I don't know that there's custody within custody, but I'll work through that. There is that other attribute, the duty to maintain public order. I didn't analyze that, and so I may need to. What is your thought about how keeping inmates in line is maintaining public order? I think of public as you're at a baseball game or you're at a street intersection, but not within a space that is generally not open to the public, except under very restrictive circumstances.
Except the public is protected by having, I believe the state would argue and the police argue, the public is protected by having those people in a locked up custodial facility where they can be kept separate from the rest of the members of the public. In part, it's because we're detaining those people for something they've done. In part, it's because we're protecting everybody else in the community from these particular people. You also in your order talked about some other cases that applied 17,752 to corrections officers. The O'Neill case, and then also the Rulane case. And if you look at O'Neill, admittedly, there's not a lot of analysis there, but they don't even talk about the power to make arrest at all in that decision. And yet the Court of Appeals held that 17,752 does apply to a post-certified corrections officer. So if it's applying to a post-certified corrections officer, what's the distinction between corrections officer and jailer?
Well, that's a question. I want to turn that right back on you. So are there 3 tiers of post-certification? You can be a peace officer, a corrections officer, and a jailer. So those are all different, I'm going to call them degrees from the post academy.
For certifications, right? Yeah. So as far as I know, yes, those are at least 3 that we have.
Okay.
Okay. So now the state in their motion to reconsider, part of their motion to reconsider was focusing on the status of Whitaker and De La Cruz. But then the other part of their argument was going back to the analysis as to whether anybody qualified as a peace officer. And they went back to refer to the definition that's in the other title. I believe it's title
30 something.
35, I believe,
Yeah.
Which does have a specific definition for peace officer and also a specific definition for jail officer. We'll go look at the definition of peace officer in title 35. There's, I think, 5 subcategories under peace officer.
Yeah.
Some of those people don't have the ability, 4 of those categories apparently don't have the ability to make arrests. Only one of the subcategories talks about the ability to make arrests. So that's just further evidence that ability to make arrest is not, the be all end all for who is a peace officer. And then they cite to the court some other code sections that are in Title 16, where there appears to be different distinctions among, peace officers and jailers. And I think those, they cite, for example, one statute, OCGA 16-546H, where in that statute, there is an explicit reference over to Title 35, which I think helps our argument, which is that the legislature knows how to specify what definitions should apply when. And if in the context of, this particular scenario that we're talking about, they could have specified that for purposes of 17,752, you ought to go look at Title 35.
They could have done a lot of things that would have helped out.
Yeah.
I hear you.
I think in general, if you look at the code sections that they cite in Title 16, they're really not illuminating as to the inquiry that we're focused on today. For example, they cite to OCGA 16-519, which is the definition section in the assault and battery chapter. And it's weird because there's a definition for jail officer, and then yet jail officer is never used again in that chapter. So query why we're defining it at all. So I would ask the court to stand by your original ruling, take out the question of whether they were post-certified peace officers, and the rest of the ruling should still remain. We don't need an evidentiary hearing. And I certainly object to, although it doesn't sound like we're going to do it, but I would object to having an evidentiary portion of today's hearing.
Well, and I didn't notice it to that. I'm pleased that they're ready to move forward with it if that's what we needed to do. But this was more of a level setting after I was educated by the state's motion for reconsideration and wanted the defense side to have a chance to push back on that, which is exactly what you all are doing. So your perspective is jailer is captured by 17,752 for the
Correct.
reasons that you've described, whether it's, hey, in effect, they're maintaining public order in this non-public space, or it just that what they do is sufficiently covered by other definitions, that because we aren't given one in 17,752, we have to look elsewhere.
And we have at least some guidance from the Court of Appeals.
With
saying that-
O'Neill.
Yes.
Okay. All right. Thank you. And your
Jason Roach, Your Honor.
Roach. Thank you. All right. Who's next?
Guess I'll go, Your Honor.
Mr. Rafis, how are you?
Doing well, Your Honor. How about yourself?
I'm all right. Happy New Year. Your client is
Omar Jackson.
Mr. Jackson. All right.
And Judge, I agree and I adopt all arguments made by my colleagues. Just wanted to point out a few things. I think in your order, I would say that you got it right, regardless of maybe the misrepresentation of whether or not there's a peace officer post-certification by those two co-defendants. But I think no matter which way you look at it, there's two prongs essentially. It's one, is there a power of arrest, which, as Your Honor said, sort of the magic keywords that generally will get you through the door. I think that we can meet that based not only on what Mr. Pines is saying, but I think as a jailer, you do have sort of a power to arrest, whether or not you're peace officer post-certified, but say, for instance, someone is trying to escape. I mean, are we just supposed to sit back as a jailer, supposed to sit back because they can't grab them and say, nope, you're being put in the hole. I'm going to limit your restraint. I'm going to restrain you somehow.
Sure.
I think
Or
that-
someone has a shank and is about to attack another inmate. These
Right.
jailers can break that up and separate people and whatnot. It's just they're already in custody. So I don't know what verb we use. And if that's what was meant by arrest, I don't know. But certainly charges can be brought. We see it, unfortunately, all too often these days against an inmate because of what's going on in the jail. I don't know if they got arrested in order for those charges to be brought or what. So it's a sort of a universe within a universe.
No, I get it. And I don't think there has to be, slap the cuffs on. Let me take you to the county jail to be considered an arrest.
Because you're already there.
I think there are some cases, and I can provide some, but just looking briefly at some secondary sources, Georgia Supreme Court labels it as essentially limiting, sort of restraining someone, no matter how slight it may be. So in my example, if someone's trying to escape, you're in your cell, which may be open for you to wander around the unit. If now you're being placed in the hole and is on lockdown, you can't do the regular things that you were able to do. I think that would be some sort of restraint, which would qualify as an arrest on the new.
Mr. Pines' argument, and
Right.
that in theory, I guess, an inmate could bring a civil suit against the sheriff's office because he was wrongfully detained, even though he is detained in the larger sense, can't leave Fulton County Jail. He was wrongfully detained, as you were describing it, in the hole or in another cell for a while as they were working through the fight that had happened.
Correct. And if we look at the 16-1-311 that Your Honor cited in your order, it's and or make arrests. So it's maintain public order or to make arrests. And that's what qualifies you under that definition. And so if I think we look at the arrest situation, which we just went through and Mr. Pines went through, but we also have the maintain public order, which I think absolutely we get there under our roles and responsibilities as a jailer, for the same hypotheticals and the same reasons as maintaining public order within the cell and within the jail. So I think no matter which way you look at it, I think Your Honor was right in the order. I think on the last page, to quote the order, they were all detention officers responsible for maintaining order and safety at the jail. And so are all peace officers, and I may have gotten that, but so they are all peace officers for purposes of 17-752. So I think Your Honor got it clearly right, regardless of whether or not two of the co-defendants were peace officer post-certified. And so that's all I have to add, Your Honor.
All right. Thank you. It's not cumulative yet. You guys are each adding something a little bit more. Mr. King, how are you, sir?
Thanks, Judge. How are you?
I'm all right.
Judge, I really don't have much else to say.
Your client is,
Mr. De La Cruz.
all right,
I went through the transcript last night, and on page 28 is kind of where I represented that my client was post-certified. I did not make the distinction, but one of the things that I didn't do is say that there were arrest powers. And actually, I just said that, for evidentiary purposes, he is post-certified. But in the next sentence, the argument was, that's really not the standard. Therefore, that's not the argument that I came to the court to make. The fact that post-certified equals that he's a peace officer under 17752. So the argument is still the same. The 3 points in addition, the 2 points in addition I wanted to make here, in addition to what Mr. Pines has said regarding in the jail, I would maintain that you're still maintaining the public order even when you are doing things in the jail, because even though somebody's incarcerated doesn't mean that they're not afforded the protections as citizens. And that's the reason why, somebody would be charged with assault for assaulting someone in the jail. You still have to protect the people that are in the jail. Somebody might be there on a suspended license. You can't have them be murdered by somebody that's on trial for murder. So you are still there as a jailer. That is one of the many duties that jailer has, is to maintain the order of the public, because the people in the jail are still afforded the protections under the Constitution as citizens.
sort of like I'm now thinking it more as like there's a cafeteria and you've got 50 inmates eating, that's a public space.
Right.
And if one of the inmates starts attacking another, jailers have to rush in to maintain that public order. It's not public to you or me. We couldn't be there, but that doesn't necessarily mean they aren't fulfilling the role of a peace officer in that sense of maintain. Hey, while you guys eat, no fighting. Not going to hit someone over the head with the tray, use the little, so they don't have knives while they're eating, the plastic spoon to attack someone.
Right. That's and we could think of 1,000 different scenarios in which people that are in jail, no matter what they're in jail for, need to be protected. And unless, or else we would have chaos, the same chaos that we would have on the streets, at the park, in your own home, that people on the outside, law enforcement officers, have to protect the public
There's
from.
plenty of chaos in my home, but we don't need law enforcement for that.
Exactly.
That's what the parents
And it may be chaos, and your job is to, keep the order in your house, but that's private. But in the public, that's necessary. Lastly, Judge, when it comes to the argument, peace officer under 17752, as already stated, is not. It's not. There's no specific thing that says arrest powers. And so when the state made their statement today, they're maintaining that post-certified means peace officer. And I just want to maintain that that's not the case. Post-certified means police officer, in that whatever the amount of hours that you need to become a police officer under post, even though post, the P is peace in post. But when you become post-certified to become that officer that we, ask them, are you post-certified when we're in court? They're post-certified police officers, and they actually maintain that in their, in their kind of their website. You become a police officer, but not a peace officer. Mr. Abadi is using the term interchangeably, but I believe that there is a clear distinction when it comes to peace officer under 17752 and post-certified, whatever you want to call it, peace or police, under what requires them to become police officers. And that's all I would say.
Okay. I think I'm the one who was using them maybe too interchangeably. Mr. Abate's helped me understand their gradations within post-certified, different certifications. And that I'll need to work through how that affects my analysis. But thank you for sharing that.
Your Honor.
We got two left. Mr. Grubman, how are you, sir?
Good morning, afternoon. I'm doing well. How are you?
Your client is?
Tanisha Strouder.
All right.
And my co-defense counsel did so well. I have nothing to add. I don't want to be cumulative. I would stand by all the arguments asking the court to stand by its original ruling.
Okay, thank you, sir. Well taken. And Mr. Majeski, how are you?
Morning, Judge.
So by process of elimination, you must represent Mr. Cook.
Yes, Judge.
Guys, due to scheduling conflict, I missed some of the arguments here today, but I think I kind of picked up on the common themes. I'll try not to be cumulative. One of the biggest things I'd like to point out, when we're talking about preserving public order, is I think that it can be extended well beyond the jail and simply what goes on in the jail. Huge Batman fan here. One of the big tropes in the DC universe is what happens when the inmates escape from Arkham. Well, one of the reasons they don't escape from Arkham very often is because they're jailers. The same thing at the Fulton County Jail.
They managed to escape just in time for a new movie each time. I'll tell you that. So it's been 2 years. We better let the Riddler go. And
Yeah.
he gets out.
Or when scientific technology needs to be advanced or something like that. However, what keeps the inmates in the Fulton County Jail? And, you know, public order, I do bond hearings all the time in the Fulton County District Attorney's Office, 98% of the time takes the position, no matter how minor the crime, this person is too dangerous to be out in society. We got to keep them in the jail to protect the public. Well, if we didn't have jailers, what's to prevent them from walking out the front door?
Big, thick doors with locks.
Which can
That work?
inevitably be broken unless there are human beings there to defeat those purposes. And that's the purpose of every jailer. And I think that when the state files a motion for reconsideration, it put the post records of all these people as attachments to all those. And I think you can see the important role that jailers play in maintaining order, not only in the jail, but outside the society, because they have training on things like, especially Mr. Cook, and I believe all the defendants, since I looked at them, handcuffing people, indicative of arrest powers, cell extractions, indicative of policing powers, weapons training, things like that look very, very shockingly like any kind of law enforcement officer I've ever cross-examined. So I think the gradation here is kind of irrelevant when we look at the function that they preserve, not only as the jail, as Mr. Pines laid out, Ms. Palmer laid out, and everybody agreed to, but what they do for society as a whole. Because if we think about it in that sense, you know, what's a jailer going to do? Do they just have to sit there and watch a convicted murderer walk out, or a convicted murderer or an accused murderer walk out the front door of the Fulton County Jail? No, they're trained to defeat that. So I think they fully fit into law enforcement. And also, and I don't know if this has been pointed out or not, but one minor point that we'll talk about later in this case, should it go any further, is I think the legislative intent is for them to be afforded the same protection as police officers, because all we have to do is look at the felony obstruction statute. Offering or disrupting a jailer in the lawful course of their duties by offering or doing violence, just the same as any cop out on the street. So I think that militates pretty heavily in favor of the legislator wanting them to afford them the same status and protection. Thank you, Judge.
You're welcome. Mr. Abate, I have a couple questions for you, and anything you want to say in response. So you believe that the records show, you're repeating yourself at my request, the post records show that all 6 were post-certified jailers at a minimum, and maybe at a maximum, if I'm creating a hierarchy of, then there might be corrections officer and ultimately peace officer. But all 6 were post-certified jailers as of September 11th, 2018. You don't dispute that?
I do not.
Okay.
They were all jailers.
You would dispute any representation, and it sounds like maybe one wasn't made. It was my misinterpretation that any of the 6 was a post-certified corrections officer, or my most egregious misinterpretation, a peace officer. You would dispute that?
Yeah, no one was a peace officer at the time of the incident.
Okay, and maybe some of the defendants got higher levels of certification after September 11th, 2018, but in some ways that doesn't matter. They could have been made pope. It doesn't, that's after the fact, and we don't weave that into our analysis.
Correct. After leaving their job as a jailer, they then signed on or were hired at police agencies and took the basic mandate in order to become a certified peace officer.
Or stay with the sheriff, but wanted to be on one of the active patrols where they're out there arresting people.
That's correct.
Okay, all right. That's question one. Question two, and you're free to decline to answer. I'm trying to work through from I don't know if it's a tactical or strategic perspective, why the state wouldn't want to err on the side of caution and say, you know what, we're going to do this again. And we're going to tell everyone when the indictment's coming down. If they want to get in front of the grand jury, they can do that. And I ask only because if I maintain my position, it sounds like there'll be an appeal. And if there's an appeal and it is sustained, I'm affirmed, this case will have only gotten another year older. It's already real old, not the state's fault, but it's old. And I worry about that. And that's not me forecasting what the Court of Appeals would do. I don't have a real good batting average right now with those higher courts. I had been doing well for 10 years, but recently not so much, but I'm working on that. I'm going to judges training actually in about a half hour. Remedial. So I'm just trying to work through that as I try to think through the different side. I understand why the defense wants me to stick with this, but insofar as you're at liberty to discuss it, why not just go back and say, you know what, we're not conceding anything, but belt and suspenders, fine, we're going to reindict. Already have affirmed your motion or ruled on your motion that not undoing any of the null process, get in front of the grand jury and act as if 17,752 applies in this situation. I mean, does it create bad precedent or what? If you want to answer.
I guess my short answer would be that it would be affording, I guess, these additional rights to those who the statute did not intend to afford them to. So if we afforded it to the jailers, then it could go as far as if you've got a security guard who, you know, is not an off-duty police officer, not in uniform,
right,
who is
Allied Barton Security at Lenox Mall, and all of a sudden you need to get that person in front of the grand jury before you can get a true bill.
correct.
Okay. Understood. So in terms of next steps, if there is, I don't know if stipulation is the right term, but if the defendants all agree through counsel that the post records would show that all 6 defendants were post-certified jailers, nothing less, nothing more, at the time of Mr. May's death. I don't know that we need to receive any post evidence. And I don't know that I need necessarily to hear more from a witness from the sheriff's office about the roles and responsibilities of jailers. I think I've got a pretty good handle on that. Where I was fuzzy was the post certifications. But I think if everyone is in agreement that that was the state of affairs on September 11th, 2018, all 6 post-certified jailers, no one was not post-certified, no one had a higher level of certification, then I think I am in a position to rule quickly on the motion for reconsideration. Is there any defense attorney who says, you know what, the state's got to put up evidence that my client was a post-certified jailer in September of 2018?
Well, the state would not have to put up evidence that my client, Mr. Whitaker, was a post-certified jailer. I would like to put additional evidence in the record as to his certification from post, which of course is the police officer standards and training council.
Peace officers.
I'm sorry, peace officers.
Don't muddy the waters any more than they are.
Sorry, peace officers. So I do have additional evidence that I would like to put in the record rather than just his records that the state printed out. But I think I thought the state said they had somebody from post here today. Is that correct?
Mhm.
They do. I'm just saying we don't need to get that person on. If everyone agrees that the 6 were post-certified jailers on September 11th, 2018, I don't need someone under oath saying I'm from post. And guess what? They were all post-certified jailers.
That part I agree with, but I think the state, and correct me if I'm wrong, state is saying that there is a post certification for peace officer. which I don't believe that there is. So that would be evidence I'd want to hear.
That would be great, because
I don't
Okay.
believe I think there's different certifications, but I don't. know.
Okay.
And maybe I could just talk to the witness for a second and I could
you
figure
could
this
just go
out.
online, it's literally on the
Who is our post person?
Julie Bradley.
Oh, not in the courtroom right now?
Is out.
Okay, probably a good idea. If you want to just chat with I'm fine making more of a record. To me, that's not advancing my analysis. My understanding is that there are tiers. My misunderstanding was what I had processed from the lawyers when we had our hearing before. But if we want to call that individual for the limited purpose of just educating on the record, all of us as to what the different certifications are, I'm fine with that.
That's why she's here.
Okay,
Or
let's do
If
it.
you want to give us, I'm putting all these other lawyers on the spot, obviously.
Let's not put them on the spot. Let's get this individual on and we'll make it official.
I might need to get on your Zoom then, Your Honor, to show our document.
So
How would I do that? Oh, I might.
You thought you weren't gonna have to do anything today.
Judge, one thing I want to say.
Hey, I need you guys to be quiet for a sec. Yes, sir.
One thing I just wanted to say, before we move forward, it doesn't change the ambiguity between the 7 and 7. Because whatever they're going to present is what posts require regarding
Hey, Grubman and team, just be quiet for a sec. Thanks.
whatever they're going to present is what is required under post. But there's no mention that has any relation to 17752.
Understood. I think this is right now you can come on up. I appreciate you being here.
And I just want to just emphasize that is a huge distinction between what the state's argument is and what the defense's arguments are. That doesn't matter what post says, that doesn't mean that they are not peace officers under what we're here for.
But I don't know, I go so far as say it doesn't matter, but it may not be dispositive.
Understood.
Okay. All right. Deputy Gordon.
Thank you very much. Testimony was good. That was true. Nothing but truth to us. Go ahead and have a seat. Thank you, sir. Your name on the record.
Julie Bradley, BRADLEY.
Thank you for being here, Ms. Bradley. I think this will be pretty brief. Mr. Abate, do you want to ask questions?
Yes.
Okay.
Good afternoon, good morning. Can you tell the judge in court how you are currently employed?
I'm the Director of Operations with Georgia Peace Officer Standards and Training Council.
And how long have you been the Director of Operations?
3.5 years.
Okay, and how long have you worked for the Georgia Peace Officer Standards and Training Council?
Can we call it post for short?
Yes, sir.
Okay.
How long have you worked for Post?
Almost 29 years.
Okay, and can you tell the court what does Post, what does it do?
We certify and regulate the activities of peace officers, jailers, corrections officers, et cetera, anybody that we certify.
And can you tell the court what are there different classifications of Post certifications within your agency?
Yes, sir, there are.
And can you tell the court what those different classifications are?
We certify peace officers, law enforcement officers. We certify jailers, corrections officers, communications officers, juvenile corrections officers, and a few others I'm sure I'm leaving out.
Is there a difference between the first two you mentioned, peace officer and law enforcement officer?
For the purposes of Post, yes, sir.
What's the difference?
Peace officers are required to go to 408 hours of basic mandate training and keep their training up every year with the governor's initiatives and 20 hours total training to include firearms. They have the powers of arrest and can enforce criminal and traffic codes. Jailers are,
So I was asking about peace officer and law enforcement officer. Are those synonymous or there are distinctions?
It's ambiguous.
Okay, but a law enforcement officer would be a curriculum closer to the peace officer end of things than, say, the communications officer.
Yes, sir. Law enforcement officers are peace officers. Yes,
Okay.
sir. With the 408 hours of basic mandate. Yes, sir.
Okay. Could you help me understand the difference in the certification for a corrections officer and a jailer?
Corrections officers go to school for about 2 months, I believe, sir. They do get firearms training.
And jailer trainees do not?
No, sir. They have 80 hours. It's a 2-week class, and they do not receive firearms training and do not have powers of arrest. Corrections officers can have powers of arrest if they are designated by virtue of their job assignment by the warden. So some of them carry firearms and some of them don't. Most of them don't, but they do get firearms training in corrections officer basic mandate.
Okay. Whereas the jailer training to get the certification, it sounds like it's much shorter, no firearms. And there is not a path that gets them the official power of arrest as designated by a warden.
No, sir.
Okay. All right. Mr. Abate, did you have other questions for Ms. Bradley?
Just very briefly, if once certified as a peace officer working for a police agency, are there any requirements that the peace officer has to continue their education yearly?
Yes, sir. Every year they have to get 20 hours of training. Those 20 hours include 5 hours of governor's mandates, which are firearms, use of deadly force, community policing, and de-escalation. One of those is 2 hours.
And
then another 15.
Does a jailer have the same requirements?
No, sir.
The only training they receive is the initial 80 hours?
Yes, sir. Classes they take, like the difference or no?
No, I'll make it ambiguous. No further questions, Judge.
This may be outside your scope, and just tell me that. A jailer gets her post certification as a jailer, working at a jail, and the head of the jail, so it's a county jail, it's really not a warden, so the chief of the jail, whatever we call that person, says, hey, there's a fight going on in the cafeteria. You 3 jailers, go grab the people who are in the fight and take them to the hole. Should they not do that because they weren't empowered to make arrests through their post certification, or they better do it because their boss told them to do it?
Are they inside the jail?
Everything I'm talking about is inside the jail.
If the person's in custody and they're inside of the jail, the definition of jail officer is that they supervise inmates. So I would assume that breaking up a fight would be part of jail officer duties.
Okay, and I know I'm taking you outside your area of expertise. I'm just, you were emphasizing corrections officers could have the power of arrest if the warden said so for certain limited offenses. What's an example, if you know, of the kind of offense for which a corrections officer who's been so deputized by the warden could make an arrest for?
Your Honor, I'm so sorry to interrupt, but I think we are veering. I thought we were going to do more of, just with all due respect to the witness, more of just kind of like a records custodian thing. And if we're veering into.
I thought just the opposite. I thought what Mr. Pine said was, let's bring someone in who can tell us what these. Mr. Pine stood up and said, there's no such thing as a peace officer certification. And Mr. Abate said, well, there is. We've got someone here who can do that. So I'm just talking about what the different certifications are. I understand that this witness has nothing to say about how the Fulton County Jail operates, line of authority, anything like that. I was just trying to understand what she was explaining, that you can get a corrections officer certification and there's a way you could ease into having some arrest authority. But with the jailer, according to Post, that's not how it works.
So I don't object to just asking what the certifications are, but if we're going to dig deeper into that, what does each certification encompass or involve, then I would ask that we not do that now, reset this for a later hearing so we can get the records. We didn't even have, and I've forgotten her name. I'm so sorry. We didn't have her name before today. So I'd like to do more preparation if we're going to go beyond just what are the certifications that Post issues.
Okay, you don't need to go beyond. I'm going to ask her to answer my question and then I'll hand it over to you all. Do you remember my question before my question was objected to?
Maybe an escape,
Okay,
but they don't go out and enforce the laws of the state of Georgia.
understood. Okay, thank you. Mr. Pines, do you have any questions for Ms. Bradley?
I do, if I could just show the stated document. I'm gonna mark this D1. Does that work?
Why don't we call it
D Whitaker?
D Whitaker 1? Yeah, Whitaker 1, something like that. I don't think there'll be a ton of exhibits, but let's keep them defendant specific.
May I approach the witness?
Please.
Let me show you what I've marked D Whitaker 1, and just tell me if you recognize what kind of a document that is.
It looks like the, for lack of a better word, diploma that we give them after they've completed the basic jailer certification training program.
And when you say we, you mean Post?
Yes, sir, I did.
Okay, and there's 3 pages as to D1, is that correct?
Yes, sir.
And would you read the top of page 2? First couple of lines?
Congratulations on receiving your Georgia Peace Officer certification.
I'm assuming you're admitting this if we're.
Right, if you want her to publish it like that, why don't you tender it first?
Move to admit D Whitaker 1.
No objection from the state.
All right, it's admitted.
Can you reread that now?
Congratulations on receiving your Georgia Peace Officer certification.
So my client was given a certification as a peace officer, correct? And I understand you're saying that the different levels of training are different, but he was given a certification as a peace officer, correct?
As a peace officer, according to this document.
Correct. And if my client's a jailer and all the other co-defendants are jailers, you would assume that they completed their training, they would have received similar letters from Post, correct?
Yes.
That's all the questions I have.
All right. Does anyone else have questions of Ms. Bradley? All right, Ms. Clark Palmer?
Bradley, I apologize for forgetting your name. Just doing too many things at one time. Am I right that Post issues certain sort of basic certifications and then also specialty certifications?
Yes.
Okay, so for basic certifications, I'm going to run through a list. And would you tell me for each one if that's a basic certification issued by Post? There's basic law enforcement, correct? GBI investigator,
Yes.
sheriff,
No.
okay? Communications officer,
Oh, wait, you mean the sheriff?
sheriff. All I can say is sheriff, and you can say yes or no.
Ah,
Is there one for the county sheriff?
yes.
Okay. As distinguished from like a sheriff deputy or?
Correct.
All right.
Yes.
Okay, communications officer,
Yes.
GBI narcotics agent,
I don't think we have that one anymore, but it was at one time.
correctional officer,
Yes.
probation officer,
Yes.
parole officer,
Yes.
a GBI forensic scientist,
I believe that's a voluntary certification. I can't say it's mandatory.
okay, juvenile correctional officer.
Yes.
And then there are specialty certifications such as jailer.
That's a required certification.
Okay, so you would call that like a basic certification.
Yes.
Okay. All right, so specialties are ones like radar
Yes.
and laser.
Yes.
Okay. In the basic certification for basic law enforcement, are you sort of using that term interchangeably with peace officer?
Yes.
There's not a separate certification for quote unquote peace officer.
Correct.
Okay, it's basic law enforcement, right? Yes,
Yes.
okay. And sometimes we call that peace officer.
We call it based at Post For our
Right.
purposes, we call it basic law enforcement certification. That's the 408 basic
Right.
mandate.
But the title that goes on the post records is basic law enforcement.
I would have to look.
Okay, may I approach, Your Honor?
You may.
Get that, refresh your recollection about the title of.
Yes.
Those are all my questions.
So that I'm clear, Ms. Bradley, so basic law enforcement, that's the 408 hours, and you basically, you are what I would call a police officer now?
Yes.
Okay. And that's not some subset requirement for all those other categories, communications, jailer, corrections. That's, you go through what we're calling basic, but it is the fundamental, you're now a police officer.
Yes, sir. The basic 408 mandate. Yes. sir.
Basic, and 408, that's hours.
Yes, sir.
Okay, thank you.
Thank you.
All right. Does anyone else have questions for Ms. Bradley? Mr. Majeski?
Good morning, Ms. Bradley.
Morning.
You're not a member of the Georgia State Legislature, are you?
No, sir.
And nobody employed by Post is a member of the Georgia State Legislature, are they?
No, sir.
Post isn't part of the Georgia State Legislature, is it?
No, sir.
It's part of the executive branch of the government, right?
Yes, sir.
So what you do is you take what the legislature says and just kind of go with that.
If it's a law, yes, sir.
Okay, but you don't make the laws.
No, sir.
Thank you.
Anyone else? Mr. Abate, any redirect?
I have a few questions.
Okay.
I'm going to tender what's been marked as stages of 1 through 6 and evidence. They are certified documents of the post records for each one of the defendants previously served upon defense counsel.
And this would be what you attach to your motion for reconsideration?
That's correct, Judge.
Okay,
Can we just have 1 moment, Your Honor?
you can.
But he needs to get to the corner before.
Yeah.
Okay.
I'm going to use it.
Oh, you are.
Any objection to the admission of states 1 through 6?
No objection.
No objection on behalf of Mr. Whitaker.
No objection on behalf of Mr. Jackson.
No objection on behalf of Mr. Stroud.
Or for Mr. Roach.
Okay. Mr. Majeski, any objection on behalf of Mr. Cook
No, Judge.
and Mr. King?
No objection.
Okay. All right, they are admitted.
Thank you, Judge. Now, Ms. Bradley, I want to ask you a specific question. Doesn't matter which you do it. I'm going to refer to State's Exhibit 1, which is the post records for Aaron Cook. So do you see at the top where it talks about officer certification?
Yes, sir.
Okay, do you see, and I'll give you, I'll read the report states at the top. When you are looking at the section that says employment history,
Yes, sir.
do you see where it says agency, rank, start date, end date?
Yes, sir.
So under in State's Exhibit 1, as to Mr. Cook's records, it says rank and it says peace officer, correct?
Yes, sir. For South Fulton.
And underneath the rank for as peace officer, can you tell the court what he was, what his prior ranking was or employment?
Jailer.
Okay. And if you go up to the certification portion where it says basic law enforcement,
Yes, sir.
is that the name of the class that they received or that they did the 408 hours?
Right there in that section, that's the name of the certification.
Okay, and in order, well, what's the 408 hours? What do you call it?
Well, if you look, I'll find it. It's, the 408 hours is going to be in the training history.
What's the name of the class?
Basic law enforcement training course.
Okay, and after someone takes the basic law enforcement training course and passes it, are they then a certified peace officer?
For post purposes, yes, they are.
Okay. And is a jailer a certified peace officer after taking the 80 hours or required course?
For post purposes, no, they are not.
And let me ask you these questions. During the 408 hours of training received to be a certified peace officer, are they trained on arrest, their arrest powers and how to arrest someone?
Just for the record, same objection that we're going into training and outside just what different certifications are.
Are you going to go deep into this, or you're simply identifying, I think what you've argued before, that jailers aren't getting trained on arrests, but what we're calling law enforcement 408s are. Okay, you can cover that one area.
So during the 408 hours is there training about an officer's arrest powers and how someone should be arrested, things of that nature?
Yes, sir.
And is that same training or done during the 80-hour jailer's training?
No, sir.
Okay. And based on your number of years and experience, do peace officers or police officers and jailers, do they take the same oaths?
Objection. I think this is way outside the scope, Your Honor.
It's attached to the indictment.
But tell me where you're going with this. I don't remember this question of the applicability of 17,752 having a lot to do with, and maybe it's something that I should have considered. I don't remember relying on the oath.
It's just the oaths the oaths describe their job descriptions, which in the state's mind is relevant as to whether jailers are considered peace officers or not. I can move on. It's not that.
Okay, why don't you move on?
And I want to show you exhibit 1. And you said that is a diploma for, I guess, what certification?
It's a certificate that we give them when they complete jailer training.
They complete jailer training.
Yes, sir.
So if you flip the second page where it says congratulations
Right here.
on receiving your Georgia Peace Officer certification. Is Georgia Peace Officer, is that the name of your actual agency?
Yes, sir.
And you're congratulating them on the certificate that they received on page 1.
Yes, sir. I believe this is the generic letter we send out for all of them.
So it's a congratulations for receiving the jailer certificate, correct?
Yes, sir.
No further questions.
All right. Ms. Bradley, thank you for joining us. Appreciate your time.
Yes, sir. Thank you.
All right, Mr. Abate, anything else?
No, nothing from the state.
How much time do I have to rule on the motion for reconsideration? I don't know if you brought the appellate people with you, but I know there's a clock ticking.
So I think your order extends it, is it to the 27th of January?
It extended it as far as I can. I'll look at my order. I just wasn't sure if anyone, but it's not tomorrow.
No, Your Honor.
Okay,
Yeah, your order says January 27th.
okay. All right. Well, I will take all this under advisement. This has been helpful. I've learned a fair amount that I should have asked more about when we had our first session. I'll get to everyone. I'm just going to work my way through. Mr. Abate, anything else for the state?
No, Your Honor.
Mr. Pines, anything else on behalf of Mr. Whitaker?
Sure. What I would say, Your Honor, is two things. One, I appreciate Ms. Clark Palmer getting to the point that I was trying to make before, that actually peace officer is not a certification that they give out. So I appreciate her doing that for me. And there is, just if you look at 17-752, it doesn't say anything about certified. It doesn't say certified law enforcement officer, because I guess under the state's theory, a law enforcement officer wouldn't be a certified peace officer under what they first argued to the court. And you understand there's different certificates that are given, or different certifications.
I do now.
My client's letter clearly says, congratulations on your peace officer certification, or whatever it says. You have the document in front of you. But 17-752 doesn't say anything about being certified. It doesn't say anything about qualifications. It uses a term, peace officer. Should it be defined? I guess it should. Is that our job? No, it's not. And the question is, who gets the benefit of the undefined term? And the answer is we do. The state never gets the benefit of an undefined term. So we'd ask you to, obviously you're going to rethink your ruling, but we'd ask that you not change it.
What is your thought about the concern Mr. Abate raised that I think is a fair one, that, well, where, and the answer may just be, I don't know where the line is drawn, but my client's on the correct side of the line. Sure. How does one avoid then having to apply 17-752 to the Allied Barton security guard?
Easy. They don't work for the government. One, and two is they can't be charged with violation of oath of office. I mean, the state wants it both ways. You swore to uphold your oath of office, as under a constitutional officer, who, by the way, is a post-certified. I believe he's I think you have to be post-certified as a law enforcement officer to be sheriff, right? So our clients work under him, and the state saying, you violated your oath under the post-certified law enforcement officer, so we're going to charge you with a felony for that.
But the charge isn't always that. I appreciate that charge is in here, but sometimes the charge is theft. You stole something from someone you arrested. They had $5,000 in their pocket, and lo and behold, that $5,000 is gone. And that was part of you arresting the person. You're like, you know what? I'm not going to declare that as evidence. And so you get indicted for having taken the $5,000. And you're a police officer. 17-752 applies. If you are a jailer, under your argument, it would apply as well. Someone is being booked into the jail, and maybe the officers didn't find everything, or guy had a super fancy belt, and then it's your belt now. So there's a theft. The Allied Barton person, if they detained someone, just freezing the scene, they work at a Target, and there's a shoplifter, and I'm going to detain this person. And in doing so, hey, just put your keys and your stuff down on my desk, and they keep the wallet. So they've now committed a theft. Why can that Allied Barton person not say, wait, before you indict me for theft, I get a chance to be in front of the grand jury because I was maintaining public order and whatnot? Because,
well, I mean, but they're not, they don't work for the government, municipality. I don't know if they are, what their certification is, if they have.
I'm assuming they have none. I mean, it'd be easy if they were off duty.
Certification, right? I mean, we didn't get into that. I assume they don't have any certification from post.
Right.
And if you take it out of the shoplifting area where they have a little bit of protection under the law to stop people, let's put a security guard in a parking lot who stops somebody, they're going to get charged with false imprisonment, for falsely imprisoning them, for moving them and taking custody of them. That's not going to happen to a jailer or a deputy or someone else who has this certification or is working under somebody who has a certification.
Okay. And it sounds like that's the line you're drawing. And that may be the right line, is that basically government worker versus private sector. And that I don't need to work through that here. That doesn't, I just, in thinking about how far 17-752 stretches.
Right. And it's if you look at under the 1613, which is what we quoted before, the peace officer means any person who by virtue of his office or public employment. So it would be somebody,
right,
office, elected office, or public employment.
If only 17-752 referred us to that definition.
If only.
Yeah. Okay.
I have nothing.
Anything
further
else?
For Mr. Rich.
Okay, let me go down my list. Mr. Rafis, anything else on behalf of Jackson?
Briefly, I agree. The distinction, I think, is you have to work for the government. Even if you look at the statute that the state wanted to use in section 35(8)(2), subsection 8, it also says an agent or officer of the state and goes on qualification. That's all I have.
Okay. And you don't need to keep answering the question I asked Mr. Pines. I understand that now. Mr. Grubman, anything on behalf of Ms. Strouder?
No, Your Honor.
Mr. King, anything on behalf of Mr. Delacruz?
Your Honor, not really, Judge, just that at the end of the day, as I reread your order, I agree that the arrest powers may have been emphasized a little bit too much. But at the same time, you did the analysis afterwards that was reached the conclusion for what you thought were the dissimilarly situated defendants. And that's the analysis that I don't believe has changed here today.
About maintaining public order.
Yes, sir. And so I would think that we have to stand on the original evidentiary hearing / motion hearings and just eliminate the arrest portion, but it doesn't mean that anything presented today should change anything. You know, as it is a motion for reconsideration based on the original presentation.
Okay.
Thank you.
You're welcome. And Mr. Majeski, anything on behalf of Mr. Cook?
Yes, Judge. My only argument would be, or additional argument would be that post definition of what a law enforcement officer or peace officer is irrelevant. If we allow them to define what the legislature said, it would be a separation of powers issue. They weren't delegated the authority to do that by the legislature, as far as I know. And then we got an administrative agency not only, affecting the law, but also encroaching on your practice and interpreting the law. So they're making the law, interpreting the law, enforcing the law. It doesn't matter. It matters what the legislature said in the statutes that have passed in the reasonable construction. So I just say that doesn't happen.
Okay.
Thank you, Judge.
You're welcome. I don't think it controls. I think it's informative because alas, the legislature didn't define peace officer. And one data point as to a definition of peace officer would be what Post has to say, but it's not controlling. I agree.
Sure, my only point though is that you're.
Yeah, well, unfortunately it is in the end. You're right. We'll see. All right. Well, I appreciate everyone's time.
Can I make one distinction or one point before you wrap up?
Yes.
Very quick.
Okay.
So just the title 35(8)(2), the definition section, the difference between that title and the one that's been referenced, 61(3). So chapter 35(8)(2), that's for the employment and training of peace officers. So it's defining what a peace officer is when you training and certifications. Chapter 16, and specifically 61(3), that's for crimes and offenses. So it's when someone has committed a crime or offense against what is considered a peace officer under that statute. So chapter 35(8)(2) talks about what a peace officer is when you receive the specific training and certifications to be employed as one. So that's why the state had made the distinction between 35(8)(2) and 16(1)(3). And what I would bring to the court's attention is that under subsection 8, where it says peace officer means, and it goes on to say under subsection A, it says, and the difference between that statute and 16(1)(3) in the definition section is it says, through the powers of arrest and whose duties include the preservation of public order. In 16(1)(3), it says for. So that was a distinction the state was making in the sense that the statute that controls the training and certifications says and I believe that to be important because that's the statutes that is giving the certifications or the requirements in order to be a peace officer and or a jailer, which it defines separately in 5.1 of 35(8)(2). So that was the reason that the state distinguish the two statutes.
They don't overlap real well. We're not done?
Well, I mean, I guess technically it's their motion to reconsider, and so they go last, but it was originally our motion. So all I'd say is 3582 says as used in this chapter.
And that is noted in my order. And I've also heard the argument 16 is closer to 17. So if there were a real clear route, I wouldn't have dragged you all back in here. We will get guidance from an appellate court at some point in connection with this case, whether it's real soon because I deny the motion for reconsideration and there's appeal, or it's down the road and hopefully a higher court will shed more light on this slightly murky area. I appreciate everyone coming in. I will get something out on or before the deadline, even if it's to say just one line, I'm not changing my mind, word it better than that, so that the state's ability to appeal, should it want to do so, is not compromised. If there is nothing else, thank you everyone for your time.
Your Honor, can we approach on something else? Real brief, it'll be really brief.
There is not another case you're involved with that I want to talk about.
Just scheduling. I cannot get a reply about scheduling, which is all I would like.
So I'm going to set it down for trial. We're not going to have another bond hearing. We're going to have a trial date.
Do we know when we're going to hear about what the trial date will be?
Soon. I thought that you were going to be busy and part of your team was busy with YSL, but I guess you'll be willing to, we're off the record, by the way. Thank you.